Well, I'm here to eat biscuits and name names, and I forgot to buy any biscuits. But remember my last video where I said the post office tried to get the judge to recuse himself, that is to say, to stand down, so they could have another trial with a different judge, because they found that that judge had already ruled against certain of their witnesses in another hearing. But I thought you might be just interested to hear just some of the comments, a selection of the comments about some of those witnesses, just by way of example. I'm not picking on any particular witnesses here. These are just, some that stand out. I'd actually like to thank a chap called Gordon Exel, who's a rather excellent barrister who runs a blog on civil litigation. And if I remember, I'll put a link to that blog in the description below, because it's actually partly it's just interesting cases, but also there's a lot of practical stuff that I think people, having everyday experience in courts might find. But yeah, I'll get on to these sorts of things. Hope you'll forgive me actually looking down, because unusually for me, I'm not just sort of like winging this by just guessing what I'm going to say, because I want this to be right, so I'm actually going to read them out. So without further ado, here's one example. Mr. Beale's way of giving evidence was very much the House Post Office style, certainly for the more senior of its management personnel who gave evidence. This was to glide away from pertinent questions, or questions to which the witness realised a frank answer would not be helpful to the Post Office. Giving evidence in court and being cross-examined is an unusual experience for most people, regardless of the amount and type of preparation that a person may have undertaken in advance. Mr. Beale certainly knew his subject very well. He sought to give me evidence highly favourable to the Post Office, which I consider was slanted more towards public relations consumption rather than factual accuracy. Now, the thing to remember is these are the judge's own words. And as I've mentioned, judges tend to try to give judgments in a very sort of neutral way. Very dispassionate. That's just where a lot of judges are. And also it just, avoids, things on appeal saying, oh, the judge was clearly biased about us. But yeah, here's another example. As with the other more senior members of the Post Office group of witnesses, Mr. Breeden is articulate, intelligent, and also acutely aware of how much the reputation of the Post Office hinges on these proceedings. His evidence was presented in terms obviously designed to put the best possible gloss for the Post Office on matters, and some of his statements simply did not stand scrutiny. The one I have explained above, that sub-postmasters had the chance to review their contracts before appointment, was expressly preceded by a statement that made clear he referred both to sub-postmasters and the NTC, that's the actual contract. Such evidence is, in my judgment, inaccurate, and inaccurate factual evidence is not helpful. When faced with the actual documents, he would agree Mr. Green's point to the contrary. In other words, when things were put to him, it's like, oh yeah, now you've put that in front of me, I've suddenly changed my mind. But one reason why the factual part of the Common Issues trial became so protracted is because of this approach by the Post Office generally. Agreement to even obvious points would be reached eventually, and the judge actually used italics there in his judgment. But getting there took much longer and a great deal more effort than it ever ought to have done. His evidence was once again given through a PR prism. And we move on. Directions had been given for the trial of the Horizon issues, the trial commencing on 11th of March 2019. As luck would have it, Mr. Green was putting the detailed questions. Mr. Green, by the way, is counsel, is a barrister for the claimants, the sub-postmasters. Mr. Green was putting the detailed questions about Mr. Abdullah's terms and conditions. Mr. Abdullah was one of the postmasters. From the lottery on Tuesday, the 20th November 2018. Mrs. Van den Bogard had signed a witness statement in the Horizon Issues trial just a few days earlier, on Friday, the 16th of November. She had dealt with these very TCs concerning Mr. Abdullah in a number of highly detailed paragraphs in other witness statements. When this was put to her a little later, and after she had had the opportunity of considering the Horizon Issues witness statement, she explained that her answer that she was coming to the matter cold was, quotes, a mistake. I reject that explanation. Her Horizon witness statement is very detailed and was signed just a few days earlier than her cross-examination. Mrs. van den Boogaard is a very clever person, in my judgment, and she had detailed knowledge of the lottery TCS Mr. Abdullah situation. She sought to give me the impression that she was being caught unprepared and had only come to the matter cold when asked witness questions in the witness box. This was wholly misleading. And like I say, judges don't like calling people liars, but so they will use phrases like, I find this is inaccurate, or I prefer the evidence of. So even to say this is misleading, and to mislead a court, bear in mind that you give a witness statement with a signed declaration of truth saying that you understand you're doing this on penalty of perjury. The one thing judges don't like is people blatantly being, quotes, inaccurate. And also, the policy seemed to be, oh, well, I'm just going to stick to my guns and say this. Well, here's a document proving that's not true. Oh, okay, then I accept that. But, and then just move on. Their starting position was, we're just going to tell all this, I'm going to use the word, BS, until and unless you can prove to the contrary. But, we go on. Some more examples. The second matter concerned a very valid point that Mr. Green put to Mrs. van den Boogaard, that she was very reluctant to give evidence that would be unhelpful to the post office's case. There are many examples of this, but I shall use just one. There were numerous internal references in documents obtained in the litigation, which Mrs. van den Boogaard had herself authored, some co-authored with other people, where she had internally accepted problems and difficulties with Horizon that are contrary to the position adopted by the Post Office formally in this litigation. And I just break back into being me now, not the judge. So this was, all these internal documents going, this system just does not work. But the Post Office's case was, yeah, it's fine, there's nothing wrong with it. In one dated 24th of October, back being the judge now, a co-authored paper with Mr. Mark Reardon, they had stated, quotes, Horizon Help, that's the in-branch operational support tool, the help feature, has since its introduction over a decade ago fallen short of delivering the in-branch self-help functionality that was promised as part of the Horizon rollout, and that postmasters and assistants desperately need, end quote. She accepted that entry as, quote, an honest and candid internal recognition of the situation, unquote, which she had co-authored. It was not surprising. The passage also seemed rather similar to the complaints made by Mrs. Stockdale in her individual pleading, Mrs. Stockdale being one of the claimants, which had said that she had, quote, access to the Horizon System User Guide and Horizon Online Help, both online, but these were difficult to use and often did not provide a resolution to the situation at hand, unquote. However, the formal position in this litigation by the Post Office is to defend the help available to sub-postmasters as being wholly satisfactory. All Mrs. van den Boogaard was prepared to accept about this complaint by Mrs. Stockdale was that there was, quote, some truth in it, unquote. But it was, quote, not entirely true, unquote, because the information was there, but sometimes took too long to find. This answer is inconsistent with the document she herself had drafted internally. This reluctance might be explained by the Post Office's formal response to Mrs. Stockdale's complaint, which was that they were not sufficiently detailed, were irrelevant, inadmissible, and were denied to the extent they could be understood. So in other words, and this is me again, the Post Office knew this system wasn't working, but when people complained about it in the litigation, they said, this system's fine, and the reason that we're not going to respond to this is because you're just rambling on and we don't even understand what your problem is. See, well, the judge didn't like them, can't you? Another one. This is a different witness. Overall, I find Mr. Dance's approach to giving his evidence unhelpful. Unhelpful is judicial, is a quite strong word in a judgment from a judge. His written evidence glossed over important points, as I explained above, and orally. Mrs. Donnelly would often have to pursue a particular point in order to obtain a straight answer. Mrs. Donnelly, who's one of the barristers. Miss Donnelly would often have to pursue a particular point in order to obtain a straight answer. I consider his evidence suffered from an overarching reluctance to provide accurate evidence, if that may assist the claimants. So again, this is me. A reluctance to provide accurate evidence. In other words, you're lying. If that would actually assist these people, you're more than willing to lie about them. And again, this is an interesting one. They had their specialist fraud investigators, and I think this witness is going to come in for a lot of stick afterwards. Mrs. Dickinson is a fraud specialist, and it is simply inconceivable that she was not familiar with the Enron case, at least in outline terms. I reject her evidence that she did not know about Enron, which I find incapable of belief. The only reason to claim ignorance, as she did, was simply to be unhelpful, which is what she is being. So again, in other words, these weren't even particularly contentious questions. It was, you're a fraud investigator. Are you familiar with one of the biggest examples of financial fraud in the sort of, 20th century, 21st century? And it's like, no. Sometimes you'll get that. You will get witnesses who will just disagree with the question, even if it's completely innocuous, just on principle. And I go on to another one now. This is... Mr. Longbottom was somewhat too ready to argue the case for the post office. For example, the previous paragraph refers to an answer from him that was only eventually reached after some difficulty. The usefulness of his evidence is limited to the points I have identified in this section. That is not to say he was always positively unhelpful, simply that he was wedded to the overall post office cause in the litigation. This sort of evidence is purely and simply an attempt to put matters as favourably for the post office, regardless of the accuracy of the evidence. Mr. Howarth had initially, in his written evidence, said that he had used the same checklist as Mrs. Ridge and Mr. Trotter. This was not the case. It is accepted when making the important correction in chief that he did. These were different checklists in use at this time. And he had not in any event even seen Mrs. Ridge's, and was simply making an assumption which in my judgment turned out to be incorrect. It is a puzzle how someone can expressly say that their checklist was the same of that as Mrs. Ridge's if they have never seen Mrs. Ridge's checklist. It is also a puzzle how a witness statement can say that a witness did a particular thing, produce a document in reference to that, but then the witness themselves say they have not seen the document. So there you go, just a few examples, but I hope you picked up on that one. I mean, basically, they've just been caught out in complete impossibilities. I mean, people were denying seeing documents that they themselves had drafted. People were guessing. People were just always giving the answer favourable to the post office, and as the judge says, regardless of its accuracy. And this is quite strong judicial language. And I think the post office themselves eventually realised that because, the recusal application came quite late. They had actually had this for a while. And I think somebody's going, this is like judge talk for you are a bunch of liars and perjurers. And it's no surprise that the judge did ultimately, pass on some of the witness evidence to the DPP with a view to prosecuting. But there you go. As always, hope you found that vaguely useful, vaguely interesting. Like I say, I'm planning something with Dan where we'll go into a bit more detail about, what are the potential remedies here? Who might the claimants go after? What might they go after them for? What might be the consequences? But, other people are covering the bigger picture far better than I am doing. So I just want to give you some examples of the actual details. So when you read and say, oh, the judge wasn't happy with the witnesses, these are just a few examples, and I could go on for hours. There are lots of examples of these, but these are just a few examples to give you a little taste of what happened and how this all came to light, and we can look at how things might pan out. Anyway, if you did find that, whatever, please consider clicking, liking, sharing, subscribing, and all that sort of stuff.